The United States Supreme Court has issued its decision in Haaland v. Brackeen, affirming the Indian Child Welfare Act. The decision was 7-2, with Justices Thomas and Alito filing dissenting opinions. A birth mother, foster and adoptive parents in Texas, and the state of Texas challenged ICWA's constitutionality, asserting that the law violated the anti-commandeering principle of the 10th Amendment. Since 1992, the Supreme Court has ruled that the 10th Amendment forbids the federal government from commandeering state sovereign power, forcing states to pass laws or enforce federal law. The petitioners also argued that ICWA employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. The Supreme Court found that ICWA does not violate the anti-commandeering principle because the law states that, quote, any party, end quote, who initiates involuntary proceedings are required to make, quote, active efforts, end quote, to keep the Indian family together, and thus does not require the use of Texas sovereign powers. In the decision, the Supreme Court points out that Texas has no equal protection rights of its own, and it cannot assert equal protection claims on behalf of its citizens against the federal government. Because Texas is not injured by the placement preferences, it does not have standing to bring equal protection or non-delegation claims. In addition to the ICWA decision, the court also issued its decision in Lac de Flambeau Band of Lake Superior Chippewa Indians v. Coughlin. In this case, the tribe in question was using sovereign immunity to attempt to collect payday loan debts from Coughlin after he had declared bankruptcy in violation of U.S. Bankruptcy Code. The Supreme Court held that the language of the Bankruptcy Code designating, quote, foreign and domestic, end quote, governments applied to tribal governments as well. The decision delineates that U.S. Bankruptcy Code, quote, unequivocally abrogates the sovereign immunity of all governments categorically. Tribes are indisputably governments. Therefore, Section 106A unmistakably abrogates their sovereign immunity too, end quote.